Hello, everyone, and welcome. My name is Jamie Gilpin. I'll be your host for today's event, Creating an Immigration Policy for Your Organization, presented by Envoy. And many of you are familiar with us here, but thought I would give a quick, there we go. There I am. And I will introduce Allison in just a second, but before we get going, this is presented by Envoy. For those of you who don't know us, Envoy is a leading immigration services provider. We combine expert legal representation with technology to provide the only enterprise platform that enables companies to effortlessly hire and ultimately mobilize their global workforce across borders. So that's everything from navigating U.S. immigration to securing global work authorization and business visas, to really tracking and managing all of your international employees, and most importantly, ensuring compliance and peace of mind that everyone is under the right status at the right time for what they are doing. And so we do that for over 1,000 companies across many industries, locations, and company sizes, and honored to do so. A few housekeeping items before we get started. So this session is being recorded. So we'll be sure to send you that recording for your reference to share, but also with the rest of the people within your organization that it makes sense for. The presentation will last, this one's probably going to last a good 45, maybe even 50 minutes. There is a ton of information here, and we'll go over the agenda in just a second. But that will be the length approximately of the presentation, and we will try to leave some time for question and answer. And so to do that, just to ask a question, please use the question function on the right-hand side of the webinar screen that you see there. And just to give a little bit of background, so I'm the CMO and Workforce Trends Analyst here at Envoy, and soon we'll go over some workforce trends that we're seeing from an immigration perspective. But really the main event of this presentation is really Allison Krantz, who is our main speaker today, and she is the Immigration Solutions Partner here for Envoy. We're really honored to have her here on this webinar. She has a vast experience as an immigration attorney, formerly at Maney & Gordon, but also spent some time at Ogletree and Deakins. She represented Fortune 500 companies and really advising them on their business immigration matters. So really honored to have you here, Allison.
Thanks, Jamie.
Yes, glad you are here. So as far as the agenda goes, so like I said, I'm going to dig into just a few high-level immigration trends, and then we will dig into really, like I said, the meat of the presentation, which is what Allison will cover, and really leveraging her experience and know-how to share with you a primer and a foundational knowledge for why and how to build a corporate immigration policy for your organization. So that's everything from what to consider with visa and green card sponsorships, to how to develop payment or reimbursement guides, especially for things like green cards, and really just an overall draft of what a policy should contain and what it could look like. Like I said, there's a ton of content here, so we will really try to get through all of it, obviously, but also leave some time for questions. So before Allison jumps in, I'm going to give a quick primer. So for those of you who have joined some of our webinars in the past or have been to our resource center, hopefully you've seen the immigration trends report that we do annually. So we do this report, over 400 employers respond. We actually partner with Harris Poll Nielsen to ensure accuracy of the sample, and most importantly, accuracy and insights into the data. And so this was conducted earlier this year, and what we found, and not too surprising, and why this really sets context for why companies are actually investing more, not only in their immigration policy, but most importantly, really in hiring foreign national talent. So 55% of employers expected their company's foreign national headcount to increase this year in 2018 or 2017. I think what's of note there is that's a significant increase from the 34% that was last year. Why is that such a big increase? Well, not too surprising. The reason why employers are hiring internationally, really mobilizing their workforce globally, is this talent fills a skills gap. It makes companies more globally competitive. Foreign nationals bring valuable new perspectives to the way the company does business because of that cultural and really just experience that they have. Obviously, they've got knowledge of markets, and also from an international transfer perspective, they're really critical to managing and most importantly expanding that global business. And so, part of what Allison, or the focus of what Allison will go over, is really around what an immigration policy specifically at an organization should be. When the green card policy, or when the green card should be started, what of that would be covered, travel policies, things like that. But something else that companies are investing in is really the benefits package. So kind of the friend, right, to the immigration policy is that what should the benefits package look like for foreign nationals. And this just gives a little context of how much employers are investing in their international talent, where 38% are spending over $16,000 for each individual. And again, this is just on the benefits and perks. Not related to necessarily the visa sponsorship cost itself. To give a little bit more context on that in terms of what those perks are, so vast majority are spending at, investing in their employees by covering their dependent visas and green card applications. They're covering travel. We're seeing this actually start to increase, that companies are covering travel to and from their home country. They're covering housing, not too surprisingly, especially on the relocation side, immediate green card sponsorship, and we've actually started to see that shift this year. Really over the last few months, we've had several employers and customers of ours change their green card policies and actually start those green card policies sooner. But we'll talk about a little bit more of that benchmarking in just a second. Everything from that to cultural assimilation training. So as we think about that in this context, really the importance of creating an immigration policy, a lot of the employers that we talk to today are just starting out in this process because either one, they're scaling, right? So they're hiring more and more international or foreign national talent. And they're starting to grow out of the case per case basis. This employee gets a green card in 1 year, this one gets it in 6 months, to having a more transparent and most importantly, equal type of policy for all of their employees. And most importantly, and Allison will cover this in just a bit, just the mere fact of having an immigration policy actually gives you a competitive advantage for this highly sought after international or foreign national talent. So as the skills gap continues to be an issue, as retention continues to be top of mind for employers, really using an immigration policy, and most importantly a competitive immigration policy, can be that difference between getting really great talent for your organization or not. So without further ado, I will pass it over to Allison to dig into all of the wonderful details of immigration policies.
Great, thanks, Jamie. And as we're going through the different slides today, you're going to see two reoccurring themes come up in what I'm saying. And those two overall themes are really, number one, leave room for flexibility in your policies, leave room for exceptions, because there's always going to be that very highly desirable candidate that you just need to have, and you don't want to put yourself in a place where that you can't approve the appropriate immigration strategy for that person because you've really set yourself up in a situation where you can't go beyond the walls that you created on your own. So keep that in mind as we're going through everything. Number two, the other thing that you're going to see throughout the presentation is before implementing any type of change or policy, make sure you consult an attorney. And not necessarily just your immigration attorney, but also your general counsel, because what we're talking about today involves more than just immigration law, but also areas of law such as employment and labor law, contract, and even tax law. So you always want to discuss with general counsel and your immigration attorney the impact of what you plan to do before you do it. It's just a wise decision. So as we're going through everything, you want to keep in mind there's not necessarily a one-size-all strategy for immigration. Now, what we're looking at here are a number of the most relevant visa categories within the employment immigration space. A lot of you are probably familiar with a lot of these categories. So I'm not going to go through each of them in detail. We have other resources for that. If you're interested or need some more support or help with that, just let us know, and we're happy to share those resources. But some of these other categories can be very useful, and they're not necessarily used as frequently as others. When you're going and you're choosing immigration policy for your organization, there's really great value in creating a list of visas that your company is willing to sponsor. If you're going to go and you're going to make that list available to employees and candidates, clearly communicate what type of visas you're willing to do and what type of visas you're not willing to sponsor. There's a couple different reasons for that. Now, number one, it's going to take a couple items off your daily to-do list off your plate. You're going to save some time because that list is going to be available for people, and so hopefully they're not calling human resource departments asking those questions if those resources are be made available in other places. However, it also clearly communicates what you're willing to do and what you're willing not to do. However, I would suggest that strong policies often have a non-exclusive list, again, to allow for that flexibility. From the perception and from the perspective of an immigration attorney, every case really is different. You don't want to close the door to visa categories that might make sense for a particular individual when they don't necessarily meet the goals of the masses. Rather, there's value in affirmatively communicating, yes, we sponsor this type of visa, but we'll consider others also. It's important to set expectations, but equity is also very important here. So you want to consider the pros and cons of how this impacts you and your company as you move forward. Some of the visa types that are really worth considering here that you'll want to look at a little bit closer that aren't frequently used are some of the, I guess, alternatives to the H-1Bs. People on this call, I assume you know that the H-1B visa is very popular and is also limited in number of who can use that. And so the H-1B1 visa, okay, for free trade agreement professionals from Singapore or Chile, or the E3 for professionals from Australia, as well as the TN visa. Those can be great alternatives. TNs are made available for professionals from Mexico or Canada, but unlike the E3 and the H-1B1, which are available to a greater percentage of the population based on their particular credentials, the TN is going to be limited to a particular list of professions that's within those treaties. So that might be a good alternative, and they're not filed in the same quantity as the H-1B. So you might want to have that conversation with your immigration attorney and see if those make sense for you. Now, in this next slide, we're talking about what type of visa categories make sense for us. What type of visa categories do you want to sponsor? You need to factor in a number of different considerations. Now, the individual pros and cons of the particular visa types, that's obvious, that makes sense. How do the strengths and the limitations of each type impact you? So we talked a little bit about how the H-1B is limited in number, but perhaps considering the H-1B1 or the TN makes sense. And how would that then affect your organization? Well, if you're going to not be able to file H-1Bs for all the candidates you hope to, then maybe that means that some of your budget for your recruitment strategies are focused on countries like Canada, Mexico, Australia, Chile, or Singapore. It's the long-term planning as well as the short-term planning that you want to pay attention to. But additional factors that need to be considered when creating these types of strategies are things like, how does the general political climate impact the policy that you're creating? That's obviously something that's very currently relevant. And in that consideration, you want to consider what rules can the executive branch change on their own, or what rules can only be changed through an act of Congress. How do these variables impact your visa category choices? And that's a great conversation to be having with your general counsel and with your immigration attorney, because you might choose that although traditionally you have gone with the strategy of one type of visa, maybe that doesn't make as much sense going forward. Maybe it'd be better to diversify your population or your visa sponsor population and reach out and try different types of visa categories. Another consideration, has there recently been a scandal involving foreign nationals holding a particular visa category? Now, this hasn't happened for some time, but generally what happens is if there's a high-profile crime committed or fraud, which we all hear about, generally whatever type of visa category that particular person or individual or company was on, all of a sudden receives much higher scrutiny at the USCIS or consulate level. And so although there isn't anything significantly happening at the current time, that's also something to keep in mind as we move forward and we're making these policies. Another consideration, has your company had problems in the past obtaining certain type of visas? If so, why? What were the officers asking in those RFEs or those NOIDs, the notice intent to deny? What does the denial say? Is this something that can be overcome by tweaking current internal practices? Maybe, maybe not. Maybe it's just something we have to plan for and we have to expect moving forward. Immigration sponsorship really shouldn't be driven by the forms. It should be driven by a finely tuned legal strategy. And so these are great conversations to be having and things to be considering before you move forward with your policy. Now, I want to point out that oftentimes immigration becomes transactional. Okay, it's easy to think of immigration in terms of the company perspective as filing this group of papers for this particular person, okay, item by item, case by case, step by step. And immigration counsel, well, they prepare the paperwork, it's filed, the foreign national waits a very long time, or maybe not so long, and then eventually they get a visa or a green card. It sounds so simple, doesn't it? And I hope everyone is laughing now on your side because we all know it's not so simple. It's definitely it's a bad habit to get in to think of immigration as transactional. That's where we can have some problems. It's significantly beneficial to have a service provider that understands a holistic immigration strategy and is able to implement that for your company. Okay, so a holistic program contains customized policies that considers how these different variables impact your particular business. Policies shouldn't be created just to make things easier. They should really further your organization and the organization's objectives and goals. So when creating these policies, you should be considering how the policies help you make appropriate decisions going forward and how your foreign national population and the goals that you share with them are going to be furthered by your decisions for the short term, but also in addition, how those short-term decisions are also furthering your long-term goals. And hopefully you're working with immigration counsel that's supporting you in that way. And if you're not, please let us know because we would love to help. And we can also provide further guidance to you and some resources and collateral on how to get you back on track and on the right page.
Great, thank you, Allison. Those were such important points. I think that's something that's overlooked because we do hear that a lot. This does become a challenging process, and so people think of it as this transactional part of their business, but really using immigration and this ability to hire and really mobilize your talent around the world is a critical part of how companies can be successful, not only from a talent perspective, but obviously meeting their business goals. So thank you for that. That was a great intro. So we're going to dig into some of the details of those policies, and one of them, and probably the most frequently asked questions from customers is, in my policy, what is the benchmark for green card? So I hire someone on an H-1B transfer or any of the other visas that you showed before. At what point do I start? Should I start a green card sponsorship? That's the first question. Will you sponsor green cards? Because that's the first question to answer. And then second, when do you do it? And so according to that immigration trend study that I referred to before from in partnership with Harris Poll, we found that 71% of employers do sponsor green cards, and that's actually up significantly from last year, from our 2016 report, up from 63%. And then the next question, of course, becomes, when should we start it, or how do we make that decision? And so you can kind of see there, it is a bit all over the place, so case-by-case basis in some, and Allison alluded a little bit to that. It's at the performance, at the leader's discretion on performance, at the performance based on the leader, and then basically just based on the business unit or leader's discretion, and then tenure. And so tenure, although a smaller portion, I think is probably the easiest one to take in terms of when you start it, but we'll talk about that in just a second. Before we get into that benchmark, we'll go over just at a very basic level with Allison around what are employment-based green cards and the options there for employers.
Okay, great. And in making these decisions, one of the first decisions, of course, is are you going to sponsor green cards or not? But I'm going to assume the answer is yes, okay, or you're seriously considering doing that moving forward if you're on the call today. And so really, the first decision that we have to make is, will this policy be employee-driven or employer-driven? Okay, what is your company culture like? Are you sponsoring foreign nationals for one period of visa status, the second, subsequent beyond that? What does your recruitment strategy look like? Are you trying to fill open positions? Are you considering sponsoring green cards in order to recruit top talent? Are you seeking loyalty? Do you expect an increase in tenure if you sponsor green cards? All of these are really important questions to consider. Now, if you have an employer-driven policy, that policy, you're going to ask the question, what is the most appropriate action for my organization? Is sponsorship valuable only to the company when it's aligned with an employee's particular performance? Or does there need to be some type of business necessity aligned before sponsorship moves forward? Is it important that the employee demonstrate a certain amount of loyalty before you move forward in the process? Does the company have a desire to invest in employees who are underperformers? If you go and you implement a policy across the board and you give everyone access to this, that means including underperforming employees in green card sponsorship. What is the real cost of replacing an employee? What is the cost of turnaround? How does this compare to the cost of individual visa sponsorship? All of these things should be considered. If, however, you're looking at an employee-driven policy, then what is most likely going to be considered is what are the particular goals, long-term and short-term, of that employee. And that includes career as well as family and life, okay? Because this person's coming to the United States for a particular profession, for particular career goals. But of course, it also does not only include that foreign national employee, but also their family. And so what does that trajectory look like? How can we help that person achieve their goals? It's very important that you consider that that employee is relying on that green card to feel safe and secure. As soon as you make that commitment, they're going to demand it. They're going to expect that you deliver that green card when promised. And it really kind of gets back almost to the Maslow hierarchy of needs. Okay, in order to reach our full potentials, first we have to feel safe and secure. And really, this is just a very basic aspect. So if you're going to promise something, it's important that you're able to deliver that. Will a green card help that particular employee feel happy, feel valued? How does employee satisfaction result? Does it result in greater loyalty? Is it just going to keep someone here for a number of years? Can we expect that person to stay with your particular company after they get a green card? All of these things are important to ask. Now, what I'm going to suggest is that very frequently the goals of the foreign national employee as well as the goals of the company align very well. Occasionally there can be conflicts, but most of the time your goals are very well matched. And so, in my personal opinion, often the best policies are those that have enough flexibility to defer to an employee's interest, but it defers to the employee's interest within the broadly set parameters set by the employer. And so something to consider as you're planning and moving on. Now, our slide here, it mentions the 3 different categories of green cards that most likely you're going to be filing on behalf of your foreign nationals. Okay, the EB1 category is organized based on the individual credentials of the foreign nationals. Skipping to the bottom of the list, the EB3 skilled or other workers, they're not based on the individual credentials of the foreign national. They're going to be based on recruitment, firm-based recruitment, if you're familiar with the term. And essentially that requires 2 things. Number 1, no U.S. worker is available and willing to accept the open position. Okay, so you're only able to actually assist that person in getting a green card if you are not able to find an already available U.S. worker to fill that. And number 2, it's also organized based on the actual requirements of the job. So even if the job requires only a bachelor's degree and the foreign national employee that you have who's in that position has a doctorate, a PhD, that PhD is not necessarily going to benefit that foreign national in any particular way. They're still going to be in that lower category because it's organized based on the requirements of the position. Now, the EB2 category is a mix of both different types. So there's perm recruitment in the EB2 category, as well as some categories that are organized based on the individual credentials of the foreign national. And the reason why we bring this up is because these different categories have different timetables. And the timetables are priority dates that correlate with these different categories very significantly. So if you're not familiar with the priority date system or how these timetables work, you want to make sure that you have an in-depth conversation with your legal counsel and do some research and read up on some of the resources that we offer, just so you have a better understanding, because some of these green cards can take really as little as 6 months, while others are going to surpass even 10 years. So that's going to matter significantly as you're moving forward. Okay, so are we sponsoring? There's lots of good reasons to sponsor foreign nationals for green cards. So, just some of those are listed here along the side. It helps employees know up front whether they're going to be considered a long-term employee, a permanent employee. A transparent policy reduces employee anxiety by communicating the company's goals and expectations for the foreign nationals prior to undertaking such investment. The application process can span multiple years, so starting early helps you get a jump start on the process. It allows companies to project and plan for future immigration-related costs. This is becoming more and more important as immigration sponsorship becomes more and more important. Before, I feel, at least in my personal experience, immigration wasn't looked at as a recruitment strategy. Now it very much is, and so it's important to be able to project those costs so they don't come to a surprise as particular managers or departments after the fact, after they've already made certain commitments. So that's very important to consider. There's a lot of good reasons to go forward. Now, strategic immigration planning reduces costs by considering both short and long-term goals, and good policies also favor dedicating resources to permanent solutions over temporary work authorizations or extensions. So employers have the ability to implement cost-effective immigration strategies that favor green cards over filing extension after extension after extension. Now, don't get me wrong, there's really good reasons to keep filing extensions rather than green cards sometimes, but that needs to be considered on a case-by-case basis for particular individuals after consideration with an immigration lawyer. Now, although it might make sense and it might be more cost-effective to sponsor a green card rather than extension after extension after extension, however, there might be very good legal reasons why that's not the best choice for that person. Also, based on USCIS's current processing times and the priority dates and how long, whether premium processing is available in particular categories, one strategy might be chosen over the other. So another thing to consider. The last bullet, companies with policies generally have an easier time ensuring compliance with immigration laws. Why? Well, I think there's a couple main points here. Number one, let's be honest, there's turnover in HR. There's turnover in hiring managers. There's quite a bit of variation with who's coming in and who's leaving. How many individuals at your company are responsible for immigration? 1, 2, 3, everyone? Everyone who hires a foreign national might be responsible for that. We see quite a bit of variation here at Envoy. And so, by having a policy and setting a pen to paper and putting all this together, it makes it very clear who's responsible for what. And that's my second point. Oftentimes, the person who ends up, for lack of a better term, doing the immigration sponsorship, taking part in this process, immigration isn't really their role. It's not actually in their job description, or if it is, it's supposed to be a very small part of it. So when we go ahead and we set a policy, it is really doing a couple different things. It's really communicating the importance of following rules and regulations to your employees, and it's also providing guidance to them and explaining what their role is within this process.
Great, thank you. That's a super helpful primer, especially for the green card, just general green card policy. To put this a little bit in context, because Allison's going to go over next, kind of weighing the options of do you start the green card, when do you do it. I think it's a great point that there's probably more than just when, so more than just tenure, as we saw from the slide before, the immigration trends around, do you do it around performance, do you do it around tenure, just as a business unit, do you make those decisions? And then this just gives a little bit more context from immigration trends, overarchingly what employers are doing or how often and when are they sponsoring the green cards. 30% are sponsoring immediately. What I think is interesting there is the STEM versus all of this is quite a bit higher, actually. After 1 year of service is probably obviously the most often chosen tenure. You've got 1 year of service. It gives you a good indication of performance. 3 years, and then the 5 years you see there. And I know there are plenty of reasons why employers sponsor what tenure. I know we see sometimes on the West Coast where this talent is in even more demand, that immediately almost becomes table stakes for especially in Silicon Valley. But in other areas, i.e. the South or even Midwest, actually the numbers start to change a little bit. So even where you are starts to change the benchmarks on these. But Allison, if you could lead us through a little bit more about how companies are kind of weighing those options.
Sure. And really what we're seeing is that what's really interesting within green card sponsorship is that we're seeing larger companies more often start using green card sponsorship kind of in addition to or almost sometimes in place of a signing bonus. And that's not something that was happening as frequently as it is now. And so, rather than offering the signing bonus, that money is dedicated to the green card process and it starts immediately. It starts right away. Another way to look at this is, before you go and you want to make such an investment in a foreign national employee, you want to make sure they fit within your organization. You want to make sure that they're able to perform. It's almost like a testing or probationary period. Kind of here from 3 months down to the bottom of our list, it's kind of, it's kind of silly, but it's an analogy almost like dating. How well do you need to know this person before you make that ultimate commitment? Before you're gonna essentially go and marry them, more or less. Okay, not really marry, of course, but it's a major commitment financially as well as the time you're going to invest into this person's career. And so we're seeing at least a 3-month waiting period for some organizations just to make sure this person fits with the company culture, they're able to do the job that they claimed that they were able to do and make sure everything is fine going forward. The average waiting period is about 6 months, and it gives the company ample time to make sure that this person does fit. Some organizations are choosing to wait a longer period of time, and this varies quite a bit in what we're seeing. Some wait 1 year, some wait longer before they decide whether they're going to sponsor that foreign national or not for permanent residents. But how long should you wait? Something that is important to mention when I mentioned the Maslow hierarchy of needs, transparent policy is going to reduce employee anxiety by communicating what the company's expectations are. So what criteria is needed in order to be considered, but also how long and what that looks like. When we're talking about security, again, it's not just security in having this job or being sponsored for a green card and knowing what your particular status is going to be, but it's also, security for someone's home. Okay, are you going to be able to maintain your home and your family, your employees' children's school, their teacher, the bus driver? This is a larger issue. So offering that transparency can be very important. Also, setting the timeline helps create accountability and defines expectations for all the different parties involved in the process. It also makes sure that all those individuals that are in this process, whether it's hiring managers, direct managers, HR, higher level individuals, it makes sure that everyone in that process is on the same timeline, and it also sets provisions and levels of accountability if they're not for some reason. The employee has this policy as a tool to assist them also to make sure that the company is delivering what they promised. Also, for companies that are waiting a year or longer, you want to make sure that you have time for a contingency plan. Okay, so if the green card case that was started is not able to move forward, maybe perhaps a U.S. worker was identified and available for a particular position, or a case was denied, is there still enough time to file again? Maybe in a different position than the employee has now, maybe in a different EB category than what was filed before. But, is there time to file again? And I'm referring to the max out times for the H-1Bs and the L visas that are limited. If there's not, does that make sense for your company? Does that are you okay? Are you okay investing the resources and the time to the particular individual and then not having a backup plan? Okay, and for some companies that answer is going to be yes, and some companies it's going to be no. And so obviously no one wants to go through this process more than once, but if you must, is there enough time for that plan B?
Great, and I know another question that we get quite often, and I know there are some nuances to this based on the state that you're in, but what the other question people ask is, do we pay for, does the employer pay for all of the green card part of it? How does that typically work out? So you see here 84% of employers pay for all of the green card related fees for their employees. Where half of that, so the 42% pay for it, but have a contractual stipulation attached to it. So if they leave within, 3, 6, 9, 12 months or beyond, there's a stipulation to bring back some of those costs. And again, there's some state laws I know that you have to consider for that. Otherwise, there's a smaller percentages that pay for just part of it, and then of course there's some parts of the green card process that employers are required to pay, and so there's a small percentage that just pay those required fees for those. And just as a side, I know we had a couple questions on it. All of this data comes from our immigration trends study that we put out earlier this year. It's a study that we did with Harris Poll Nielsen in partnership of over 400 employers across the U.S.
And, in developing payment and reimbursement guidelines, our statistics here on the right-hand side of the page, 60% of visa holders say their current company offered a perk package, okay? And this is something really interesting. Jamie touched on it just at the very beginning, and it's really not the focus of our discussion today, but it's something to consider, and it's something, again, that can be worked into a reimbursement policy. 7 out of 10 companies paid immigration attorney fees. 84% of company-sponsored green cards are covered by the employer. Employers are always permitted, of course, to pay 100% of all costs associated with green cards and visas, but they don't necessarily have to. Some visas and green card categories allow for employees to pay for certain parts of the case. The various visa and green card categories have different rules and regulations regarding what expenses employers can pay for, what employees can pay for, and there's also certain mandates that explain what parts of what types of case must be paid for by that employer. Further, the law that pertains to some particular types of visas have additional provisions that say that if certain periods, certain contracts are ended early, foreign nationals' particular period of time in the United States ends early, not necessarily by their choice, then the employer is required to pay for certain costs too. So since there's a lot of moving parts in this piece, and we don't have time to go through every single particular visa type and what laws pertain to those and what don't, we want to make sure that you're speaking with your immigration counsel again on what types of visas you have, how these rules apply, and what you need to consider before you actually put this into a formal policy. Now, of course, sponsorship is an investment, and it's of great value, but there's also risk. So what we have in front of you is an example of what a reimbursement clause might look like. So on the right-hand side of the screen, some possible stipulations. An example of what might be included in these types of clawback provisions might be if an employee terminates his or her employment within 6 months of getting their green card, they're going to incur the full cost of those applications. And by full cost, of course, we're talking about the cost that the employee is actually allowed to pay, not the actual full cost of all parts of the petition, because there are certain aspects that the employer must pay. After 12 months, if they leave the company within a year after getting their green card, they might have to pay 75% of those costs back. 12 to 18 months after getting their green card, they would incur 50% of the cost. From 18 to 22 months, the foreign national employee might have to incur 25% of those costs, and after 24 months, incur 10% of those costs. And how that works, there's a lot of variation because, with these clawback provisions, these reimbursement policies, they're great, right? Because they mitigate some of the risk that you're taking when you're sponsoring foreign nationals. However, this is only going to mitigate the risk if they're executed properly and lawfully. So state law as well as federal law applies here, and the different states have different rules that vary actually pretty significantly on how these types of contracts can be used and what terms can be included in those and what must be omitted in those. Because we want to make sure that if you're developing these types of provisions, you do them lawfully so they can actually be used and reinforced or enforced into the future. In terms of federal law, how it plays out here is that the immigration law is very specific, again, on what types of visas can be used in what way. So even if a foreign national, prior to entering into this type of provision, prior to the sponsorship of a green card, was to enter a contract with you saying, yes, they would go ahead and they would pay for certain aspects of it. Later on, even after they get the green card, we still couldn't violate those federal laws that said they wouldn't be able to pay for particular aspects in particular areas of them. So even after the fact, after that person's a foreign national, those laws are still applicable. Okay. Now, we've talked quite a bit about the types of questions you want to consider before drafting a policy, and this slide helps to summarize a number of these important points. Okay, so good policies leave room for exceptions and contingency planning. You're creating a plan A and B as soon as possible, and you're making sure that there's enough time to execute plan B if necessary and if needed. You're considering the maximum time a person is able to be in a particular status of a visa category, which means you're planning for the long term as well as the short term as soon as possible. So what this might look like is if H-1Bs are limited to 6 years initially, and some green cards take 1 to 2 years to complete. As I mentioned, some of them take much longer than that, but some green cards do take, a year or two is pretty average for a number of types. Then it makes sense to start the green card no later than year 2 if you want to have time to execute plan B later. And if there's a possible plan C, okay, so perhaps plan A is great, but the attorney tells you the probabilities of success aren't great, even though it would get someone to their goal faster than the other 2 options. Maybe we do want to leave room for plan C. How would that fit in? Well, that would mean even starting sooner than that year 2. Another consideration, will you allow concurrent applications to be filed? And what I mean by this is if you have a plan A and plan B green card, okay, running them at the same time. What this might look like is, does it make sense to have an EB1 case for perhaps an outstanding researcher professor filed at the same time EB2 perm recruitment is ongoing? Okay, so you're having 2 green cards move forward at the same time. Does that make sense? It might for some organizations. It might for some people, especially for foreign nationals from India and China, if they might qualify for that EB1 case, even if it's not the strongest EB1 case. The difference between an EB1 case for an individual from China or India at certain times of the year, what we've seen historically, and that compared to an EB2 perm case, I mean, that time is significant. We're talking years and years and years difference. And so maybe it makes sense to file 2 cases at the same time. So you have a backup plan in case the EB1 is denied. So that wants to be considered, as well as the cost associated with that, and as well as the foreign nationals' desire to go through those 2 processes at the same time and what's important to them and helping them feel safe and secure in their position at your company. Now, if you are considering concurrent filing, what fees are your company willing to cover? If you generally have a policy where you're willing to file, if you're willing to cover 100% of the fees, if you have a foreign national who's really insisting on filing 2 green card cases concurrently, are you still willing to cover 100% of those fees? Maybe, maybe not. Would you make an exception for a very highly skilled, desirable candidate? Maybe, but again, you want to put that wiggle room into your policy. So if those situations arise, you're able to take advantage of that. Okay, and just kind of as a side note, as of today, in terms of concurrent filing and priority date systems and planning for long oversubscribed visa categories, as of today, there are delays in India, China, and the Philippines. So for foreign nationals in those countries, that's something you want to keep in mind of. Continuing on, some additional legal considerations that we should just touch on and are worth discussing more in more detail later on in a one-on-one setting. Sponsorship through family members. Every once in a while, I'm sure that you've had a foreign national come to your office who has the possibility of getting a green card through a family member. And if it hasn't happened yet, it will at some point. Okay, and they're letting you know this one of two things. Number one, they're coming close to an expiration date on the current visa status, and they're wanting you to know, no, the company doesn't need to extend because I'm getting a green card through my brother or my spouse or some other family member. Okay, so we don't need to extend that. Or perhaps, it's the foreign national asking you, all right, well, I understand that you're willing to pay the costs associated with this employment-based green card, but I just married a U.S. citizen, and the U.S. citizen spouse would like to sponsor me, so would you be willing to commit the funds that you reserved for my green card through the company to my spouse, so we can pay for our green card that way? That can be a great option. That might even be a faster option than some of the employment categories that are available to get that person to permanent residence sooner. However, there are some risks involved here. If we're going to go through and we're going to assist this person with filing a family-based green card, or we are going to decide not to extend their current visa category, perhaps their H-1B, because they're going through a green card process with a family member, are you going to be permitted to see that petition and share it with an attorney to determine its merit? You want to have an attorney review that probability of success. Has that individual even hired their own immigration attorney to go through this process? There's a very, very high denial rate of family-based immigration petitions, not necessarily because those individuals don't qualify for that benefit, but just because the paperwork was filed improperly or incorrectly or to the wrong offices. So it's important to have an attorney involved just to evaluate that case. However, on those forms, those family-based immigration forms, there's a tremendous amount of information, very, very personal information that your company might not even want to see. You might want to be privy to that. It might not be a good choice for you to have access to that information. Okay, so that's something you need to consider also. There's also factors that can't be managed or mitigated by an employer, such as personal relationships, okay, fighting and even divorce. If we go ahead and we rely on this, and one of those circumstances happens, and the green card doesn't move over and get approved, then is there still time to file employment-based green card, or is there still time for that extension? This can be even more complicated. The next point here is maintaining status versus the I-765. So at the final step of the green card phase is the filing of the I-45 adjustment of status application. Well, when that's filed, the I-765, work authorization can be filed concurrently at the same time, and generally is. Now, if we have a foreign national who's approaching the end of their H-1B expiration, do we want to rely on that 765 work authorization rather than renewing the H-1B? Maybe, possibly, but there's risk involved in that also. If the adjustment of status, okay, is denied, if the green card is denied, then that I-765 work authorization, sometimes known as the EAD, expires and ends at the same time of the denial of the adjustment of status. And that's true even if the work authorization expiration date on the actual card itself, if we're not up to that date yet. So if it says that we have until December 1st of 2017, and the adjustment of status is denied on November 1st, then that work authorization ends that November 1st date. It ends immediately when that adjustment of status is denied. If that occurs, how are you going to know? That information is going to go to the foreign national. That information is not going to come to your office. So you want to keep that in mind also, because you have an obligation to make sure that you are only employing foreign nationals who are actually allowed to be working in this United States. Finally, travel policies. This is one of the most important things I'm going to talk to you about today, really. Based on my own personal experience, a lot of times when there's issues or problems or headaches or even denials, a lot of times those headaches or denials have come from situations where a foreign national has traveled outside the country and did not tell the employer or the attorney that they were going to do so. Now, it's not always a problem, but it can be an issue if the particular type of visa status they're currently on has a conflicting intent with the green card, so they're on a temporary non-immigrant visa, but they go ahead and they file a green card, and then example, that might be a TN visa, a green card is filed, and then they attempt to re-enter the United States in that temporary visa, the TN status. Those two types of categories have conflicting intent, and what I mean by that is the TN is for individuals who are coming to the United States for a temporary period and returning home. The green card obviously expresses an intent of staying permanently. Now, not all the multiple stages of the green card are filed at one time, if we're talking about perm-based recruitment green cards. So depending on where we are in that green card process, that could be a significant problem for some foreign nationals. And we're not necessarily going to know until it's too late. Also, depending on the visa type, leaving the country while the green card, certain stages of the green card process are pending can result in abandonment of that application that you filed and paid for on behalf of that individual. Also, outside the green card context, it's possible that a particular visa type gets approved for a number of years, but when that person leaves the country and the foreign national re-enters the United States, for whatever reason, an officer has the opportunity to short that period of time and issue an I-94 that says their expiration date is actually going to be sooner than what you were aware of and what you knew of. So often it's very important that you have, I would say, there's really very few reasons why you wouldn't want to include a policy that says that if a foreign national is leaving the country, as soon as they get back to the United States, they provide you with an updated copy of their I-94 form. Something that's very, very important. Just a very proactive way to prevent problems happening in the future. Make sure that information is shared with your immigration attorney. That's going to be very important to them, just to make sure that they're maintaining and caring for your cases and all of your foreign nationals. Okay. And then after we have all of our pieces of the puzzle together, we have a nice clear picture. We know exactly what we want to do and why we want to take such actions. We're going to go ahead and we're wanting to submit that for attorney review, and that's to general counsel as well as your immigration attorney. It wouldn't be uncommon for your general counsel to then send it perhaps to attorneys that specialize in the area of labor and employment law, contract law, tax law, and perhaps some experts in the state fields who can talk, who have more knowledge of those clawback provisions we discussed earlier. If you have any questions while drafting, feel free to reach out to your immigration attorney. The Envoy affiliated attorneys are always happy to help and answer questions along the way, as well as suggest those holistic immigration strategies.
Great. Thank you so much, Allison. This has been obviously a wealth of information. Thank you. You obviously put in a ton of time just preparing. So we went over a lot of information, and we are coming up up to the time. I was going through these questions as Allison was talking, just to make sure, and luckily you answered most of the questions in the following slide. So there were some questions on some reimbursement stuff, and actually on our family-based green cards and employers' ability to cover those. There was a question on digging deeper into the perm process. Just to clarify that one, or just to give you a resource, one, there are plenty of resources on our Resource Center around the perm process. There are green card webinars that we've done in the past, including those slides, so please refer to those. Fortunately, this was a level 2 webinar where we don't really dig into the details of specific visas, and we're under the assumption that everyone knew a lot of those kind of details. But believe me, we've got plenty of those resources, so please go to our Resource Center and you can grab that information. Otherwise, I think you did cover most of the questions. Lots of questions on the deck. Yes, we will be sharing both the presentation slides as well as the webinar recording itself post the, actually you'll get this right after this concludes. And you also, there are some sample immigration policy as well that is on our Resource Center. So make sure you check that out, and you should be able to get all of that. I think the only question that might be helpful just to hit on very briefly, we obviously stayed very U.S. Immigration focused. Do companies typically have a separate global one, or do they put it all together? That was really the only other question that people had.
Sure. I have seen both. A lot of times it makes sense to do them separately, just because of the issues that people are facing abroad are not necessarily the issues that we're facing inside the United States. For example, like I mentioned, the updating of the I-94, or the family-based employment versus whatever particular aspect of the perm case you're in. There's a lot of very U.S.-specific variables, so it might make sense to have two different separate policies. But I've also seen them contained as one, but just having them kind of under different headings, different subcategories. So they're under the same, I guess, document in the intranet, but still very separate.
Yeah, that makes sense, and that's probably different visa categories and all kinds of strategies. So that makes sense. And then this is more of a corporate, and actually we see almost 50-50. Do you typically see expenses coming out of the HR budget or out of the business unit budget? And I know, from my vantage point, just talking to Envoy customers, I mean, it really is like 50-50. I think half of the customers we talk to, cover it within HR, and half distribute back to the business units. Do you see the same thing?
Yeah, I agree, Jamie. And I think there's so many different variables and so many different company sizes. I think it really depends on how large your organization is. I think that's the kind of the only thing I've seen that might be a deciding factor there. But what works for one company doesn't necessarily work for the other one. So do what makes sense for you.
Yeah, I think that that is a great way to end our webinar, because I think it's a really important one. I think part of what makes this so challenging, and you don't just have a cookie cutter policy, is that every company is different. Their culture, what you're trying to accomplish from a business perspective, all goes into not only your policy, but really your immigration strategy overall. So we are very lucky, and thank you so much to have Allison on this call with us and taking you out of your day, because I know how busy you are as well. Appreciate you, and also a big thank you to all of you who are attending, taking the time to learn more about immigration policies for corporations and how you could start implementing that for your organization. As always, we are here as your partner to help, and so any legal questions that you have, there were a few on few specifics on TNs versus green cards and things like that. Post those questions to the Communication Center. Your, the lead attorney for your organization will answer those in a timely manner. Otherwise, the Resource Center, which is at envoyglobal.com/blog. Both blog and Resource Center are right there on our website to get information, resources, checklists, and sample immigration policies and everything else. As always, we are honored to be your partner. Thank you so much for joining our webinar, and we will see you in a few weeks for the next one.